This is Dr. P. Kogila, Assistant Professor, Department of Commerce from St. Josephs College of Arts and Science for Women, Hosur. Discharge of Contract. A contract is said to be discharged when it ceases to operate. That is, when the rights and obligations created by it come to an end. A contract may be discharged in any of the following ways: by performance, by mutual consent. A contract is discharged when rights and obligation created by it comes to an end. That is, the contracting parties no more owes any responsibility or liability to each other. We are going to analyze what are the multiple ways causing discharge of contract. Discharge by performance. Discharge of performance occurs when the parties to the contract fulfill their obligations set out under the contract within the specified time and in the manner prescribed. In such a case, parties are discharged and contract come to an end. Actual performance and attempted performance. For example, A repays the amount on the due date. This is called actual performance. Attempted performance. Sometimes when the performance becomes due, the promisor offers to perform his obligation, but the promisee refuses to accept the performance. This is called attempted performance. What is discharge by impossibility of performance? Section 56, the Indian Contract Act 1872 said, when the performance of the act becomes impossible due to factors beyond the control of parties, the contract stands discharged. There are two circumstances for which contract is impossible to perform: when impossibility is existent at the time of making contract, and another one is when impossibility arises subsequently after the formation of the contract. When impossibility is existent at the time of making contract, when an agreement is made which is impossible to perform, it is void from very inspection. Various alternative situations are: fact of impossibility known to parties, fact of impossibility is known to one party, fact to impossibility unknown to the parties. When impossibility arises subsequently after the formation of the contract. Sometimes the performance of a contract is possible when it is made by the parties, but some event subsequently happens which render its performance impossible or unlawful, and the contract becomes void in both the cases and hence gets discharged. It is known as doctrine of supervening impossibility or doctrine of frustration. What are the factors causing doctrine of supervening impossibility? Destruction of subject matter, failure of ultimate purpose, death or personal incapacity of the promisor, change in law or government policy rendering further performance illegal, outbreak of law. The following are the effects of doctrine of supervening impossibility. The contract becomes void and stands discharged when one contracting party has obtained valuable benefits before the time of discharge as a result of efforts done by another contracting party. That shall be recoverable from part so benefited. Discharge by mutual agreement. The contract is made by parties and therefore come to an end by their mutual agreement. The parties may make new agreements that will discharge or modify the obligations of one or both the parties under the original contract. This comes under the section 63 of Indian Contract Act 1872. Discharge by lapse of time. Discharge of contract by lapse of time is a legal concept that stipulates that a contract automatically becomes null and void once the time specified in the contract has elapsed. In other words, the contract is discharged without any need for formal termination or cancellation. Discharge by operation of law. A contract is discharged by operation of law in the following cases: if the person death, insolvency, major unauthorized material alteration. Discharge by breach of contract is: the breach of contract means failure of a party to perform his obligations. When a party commits a breach, the aggrieved party becomes entitled to cancel the contract, causing the contract to discharge. Actual breach and anticipatory breach. Actual breach means when one party fails to perform his contractual obligations on the due date of performance or during the performance, he is said to have committed breach. In anticipatory breach, when a party to contract has refused to perform or disabled himself from performing his promise, the promisee may put an end to the contract unless he has signified by words or conduct his accusations in its continuation. Thank you very much.